What is the impact of data privacy on tech IP portfolios? Imagine building a treasure chest of innovative ideas and inventions, only to find that new rules about personal data are changing how you can protect and use your treasures. That's what data privacy laws are doing to technology intellectual property portfolios today. As more companies develop artificial intelligence and other tech products, they relying heavily on data to create and improve their inventions. But laws like the General Data Protection Regulation in Europe and the California Consumer Privacy Act in the United States set strict limits on how personal information can be collected, stored, and used. These rules mean companies have to be very careful about what data they gather and how they handle it. If they don't follow these laws, they risk hefty fines and damage to their reputation. This can make it harder to defend their IP rights because the data behind their innovations might be considered sensitive or protected. When companies develop new AI models, they often need large datasets for training. Privacy restrictions can limit access to these datasets or requiring anonymization, which might change the nature of the data and affect what can be patented. For example, if data is anonymized, it may no longer qualify as a trade secret or as part of a patent application. Managing these issues means companies need to think about privacy from the start when inventing or filing patents. They also have to put strong security measures in place to protect proprietary data and trade secrets. If they fail, their IP rights could be challenged or invalidated. Using artificial intelligence tools to analyze and manage IP portfolios is becoming common, but these tools also need to comply with privacy laws. If not, their use could expose companies to legal risks or limit their ability to identify valuable patents or gaps in their portfolios. When companies operate across borders, they face even more challenges. Different countries have different privacy laws, making it tricky to manage a global IP portfolio. They need to ensure their protections are valid in each jurisdiction, which can affect how they enforce or license their IP assets internationally. Regular reviews of IP portfolios now include privacy compliance checks. This helps companies avoid legal problems and keeps their IP assets valuable and protected. In practical terms, companies must integrate privacy considerations into every step of managing their IP. From invention disclosures and patent applications to licensing and enforcement, privacy rules influence how they handle data. This approach helps safeguard their innovations while respecting individual rights. Overall, data privacy laws are shaping how tech companies create, protect, and manage their intellectual property. They add new layers of legal requirements and strategic considerations, but addressing these challenges is essential for sustainable growth and competitive advantage. By staying ahead of privacy regulations, companies can continue to innovate confidently while protecting their valuable IP assets.